Good afternoon, sir. We have been approached by our client, Mrs. Luna Darcy, for recommendations on future business structures in response to her expanding business, Cupcake Mania. Currently, she operates as a sole trader working on an order-to-order basis from her shop front on the Esplanade in Cairns. Mrs. Darcy has been operating for 6 years now and is considering expanding her business in the near future by opening another store in one of the northern beaches of Cairns, Palm Cove. Our client wants to know the best business structure for her to adopt that is cost-effective and allows her to keep relative control of her business. In completion of my interview with Mrs. Darcy, I have reviewed the advantages and disadvantages of two business structures that are advisable to her. These are company and partnership structures. In conclusion, I have provided my recommendation for our client, Mrs. Luna Darcy. Mrs. Darcy has been operating as a sole trader for 6 years, so I believe it is still important to review this business structure for our client to ensure that they understand the advantages of sole proprietorship, but also the effect it will have in regards to change. The advantages of sole proprietor will allow Mrs. Darcy to have full control of her business, as well as give her the flexibility to expand into different business structures. Unlike other business structures, there is no specific legislation regulating sole proprietorship, and hence they may be held liable to comply with other legislation specific to their business, such as unlimited liability and vicarious liability. Due to this liability, our client may be exposed to financial risk and burden. Currently, it will be simple for Mrs. Darcy to continue as a sole proprietor and operate her second shop in Palm Cove, although it is questioned if this would be the most viable option for her, as she would have to obtain a bank loan for approximately $30,000 for startup costs. This is not a favourable option for our client, as she has a small family and will not like to be financially burdened. In comparison to sole proprietorship, my first recommendation is to consider a company structure. A company is a very popular business structure as it is seen as a separate legal entity as defined in the 1987 appeal case of Salomon & Salomon & Co. Limited. This case firmly establishes that upon incorporation, a new and separate artificial entity comes into existence, having the ability to sue and be sued. The type of company I recommend is a proprietary limited company, as defined in Section 45A of the Corporations Act. This is because Mrs. Darcy still wants to remain relatively small. Therefore, the benefits of a proprietary company will allow at least one director who resides in Australia under Section 201A of the Corporations Act. Within the company structure, Mrs. Darcy's assets are separate to the company and cannot be touched to pay the debts of the business. Thus, it has a protection of the corporate veil. For Mrs. Darcy to operate a small proprietary business, she would be the sole director to manage the company. She will be able to raise the finances necessary to start up her new business through a business loan, but also equity financing will be available to her by shareholders' contribution. A shareholder could be anyone who is willing and able to buy into ownership to raise funds for business purposes. Mrs. Darcy would also have reduced personal liability for business debts and other liabilities. The disadvantages for Mrs. Darcy to operate a proprietary limited company is that it is very expensive to start up, costing approximately $1,000 to incorporate the business, including the $469 ASIC registration fees. The maintenance cost or the unexpected costs can also be quite expensive. Henceforth, it is important to consider our client's current profit for the 2015-2016 financial year was approximately $35,000. Another disadvantage is external regulation, such as ASIC. It can be quite costly and time-consuming. The rules set out in the company's constitution as followed by Section 136 of the Corporations Act or the replaceable rules outlined in Section 135 of the Corporations Act can also be burdensome, since it is a contractual obligation between the director and its shareholders. These rules confer rights onto the shareholders. Under a company structure, Mrs. Darcy has fulfilled these contractual obligations as a director. Therefore, she does have a number of duties. These include to act in the best interest of the company, act with due care and diligence under Section 180 of the Corporations Act, act within good faith of the company under Section 181 of the Corporations Act, and not to use improper use of position or information under Section 182 and 183 of the Corporations Act. Specifically, the 2003 Federal Law Report case of ASIC versus Adler proves that the directors of a company must act within the best interests of the company by using due care and skill. Also, the 1995 New South Wales Law Report case of Daniels versus Anderson, the courts decided that the director must use their special knowledge or skill appropriately within the scope of the business. In breach of these duties opens the client to civil liability and quite possibly criminal sanctions. My second recommendation is a partnership structure. A partnership is a relationship founded upon the agreement of parties which can either be expressed or implied. To be in this relationship, the parties must be carrying on the business in common with the view of a profit. Our client is willing to join in a partnership with another business person within the same industry. Currently, she is in the very early negotiations with a small pastry maker who does not have a shop front but operates on an order-to-order basis. Section 6 of the Partnership Act specifies several rules in relation to a partnership, specifically the sharing of net profits, sharing of losses, management participation, and contribution to capital. Each of these are key factors that determine the existence of a partnership. Section 6, subsection 1c specifies that the receipt of a share of the profit by a person of a business is prima facie evidence that he or she is a partner in the business, demonstrated in the 1945 High Court of Australia case of Kuenzele and Wiltshire. The partnership is advised to be established with a partnership agreement, which will outline the obligations of both partners. The partnership will involve the other partner to provide $15,000 of the startup costs and Mrs. Darcy to contribute the rest. Since the partnership is seen to not be a separate legal entity, the assets of the partnership are owned by the partners jointly or as set out in the partnership agreement. The advantages of the partnership agreement is that it is easier to set up, more cost-effective compared to a company, and easier to transition to from a sole trader. But most importantly, the capital will be available for Mrs. Darcy to start the new business in Palm Cove. The disadvantage is that Mrs. Darcy will still have the unlimited liability. She'll be personally responsible for the debts of the partnership. Since both will have a management role in the business, there is room for friction or disagreements, and Mrs. Darcy will be liable for the actions of the other partner. Also, if the other partner decides to leave, she will be left in a costly situation to buy out the other side or to find a new partner. It is therefore within my recommendation that Mrs. Darcy adopt a partnership structure. The reasoning is the client will be able to have all the startup costs covered as she has the finances available through her savings and the other partner who will be able to contribute. They will also have the shared responsibility of the business as outlined in the partnership agreement. Secondly, Cupcake Mania is still relatively small, with approximately $35,000 profit in the financial year. A partnership will be easier to manage compared to that of a company, and the startup costs are significantly lower than the incorporation fees and the maintenance of a company. Mrs. Darcy does not have the expected profits to maintain a company, nor does she have the time to fulfill the regulatory obligations of a company. And thirdly, a partnership will allow her to diversify her range. This diversification will allow our client to reach a different target market and therefore essentially to earn more profits. This is my recommendation. Thank you.